Hello, this is Cynthia Ho here to talk to you about IP. Just a little bit of an intro. So, getting started, you might wonder why we have IP, i.e., intellectual property. Well, you may have heard that the Constitution is involved, and that is true in the US. The Constitution permits, although it doesn't require, for certain types of IP to exist in the so-called IP clause. Basically, this is the basis for patents and also copyrights. For other kinds of IP, like trademarks and trade secrets, that's actually permitted under the much broader authority of the Commerce Clause. Now, IP is very controversial at times in terms of whether its scope is appropriate, so sometimes people talk about getting rid of IP. But that's actually not possible these days. Why? Because there are actually international laws that govern most countries, including the US, that require certain minimal levels of IP. So IP is definitely here to stay. So let's think about what that means, that we have IP. What are the impacts? Well, the first question you should think about is whether IP is essential for innovation and creativity. You may be thinking, excuse me, the obvious answer is yes. But there are quite a few scholars and other policymakers who've actually suggested that IP doesn't always result in innovation creativity. There are actually some areas like improv where IP can't provide any protection. Also, although IP may be valued by businesses, it's not necessarily always required. It may just result in increased profits. Now, one thing to think about is there's always IP owners and IP users, and no one always is in one position. So the impact of IP rights should be considered in terms of how it impacts not just giving potentially value to its owner, but how it may potentially limit users' rights. Now, by users, I don't just mean people who are passively using, but even researchers and subsequent innovators and creators. So IP rights can limit access to protected work. It can also result in increasing costs of works. Now, this is true whether you're talking about a patented drug or a copyrighted textbook. Because of copyright, textbooks commonly may cost $200 as opposed to the amount of money it would take to print it. So there are upsides for businesses that have IP, but potentially downside for users in society who want to use IP. And even somebody who wants to do a sequel or do fan fiction, they may be barred from doing that without facing an IP lawsuit with IP rights. Now, let's think about types of IP. I've listed the most common types of IP here: trade secret, utility patent, copyright, trademark. And I'm going to suggest that these images here are relevant to some of them. You may have heard that the formula for Coke is a trade secret. What that basically means is a trade secret is information that's valuable from being secret, not known. Also, the Coke bottle involves another kind of IP, which is a trademark. The name Coca-Cola indicates its source. So Coca-Cola indicates a different kind of beverage than, say, Osco Cola. You probably have a preference for one versus the other. Now, there's two other kinds of IP as well, patents and copyrights. Patents tend to be for inventions, some of which could be a trade secret, but there are harder standards for patent protection. It has to be actually new and something called non-obvious, whereas a trade secret just has to be valuable from not being known, but doesn't have to be new or uncomplicated. Copyright is something that is more commonly used for expressive arts. So it could be music, movies, books, sculpture. The Tesla symbol you're seeing is a trademark because it indicates the kind of car, but I also have it there to represent that Tesla could have valuable patents in terms of how its cars run. So these are some kinds of IP. Now, in terms of copyright, you may be wondering what could be a copyright. I gave you some examples, but the basic rules for copyright is that it has to be, quote, original work of authorship, i.e. you didn't copy it from someone else, and it has to be fixed in a tangible medium, fixed so that you can perceive it. That's all that you need for a copyright. You may have heard you need to apply, you need to register. That's not true. To have a copyright, there are benefits from registering, but you do not need to do any of that. So for all these kinds of IP, you actually don't need any government involvement except for a patent. A patent isn't valid unless you apply and the U.S. Patent and Trademark Office decides that you have satisfied all their criteria. Otherwise, there could be benefits from registering a trademark or registering a copyright, but it is not required. And you actually cannot involve the government at all with a trade secret. You just have it be reasonably secret, and that's it. So that's a little bit of an overview. The one last thing I'll say about the scope of IP rights is they're not all the same. Patents are generally considered to be the most exclusive, but copyrights also can exclude others from using it, although it's subject to something called fair use, which is pretty broad, as well as various statutory exceptions. Trade secrets and trademarks do not exclude others as much. Importantly, for trade secrets, you can't exclude those who independently invent the same thing or that are able to reverse engineer, i.e. figure out your trade secret easily. For trademarks, you sort of can exclude others, but only if people would be confused. So, for example, with Coca-Cola, if somebody had something that was spelled Coca-Cola with a K, maybe other people would be confused. But maybe if it was in a different script, no one would be confused. And then even though it's similar, you can't actually prevent use. So hopefully that was a helpful overview. Thanks.